Let's go to number 87, People versus Scott. Counsel, would you like any rebuttal time?
2 minutes, please, Your Honor.
2 minutes? Sure. Go ahead.
Good afternoon, Your Honors. Jose Sakushi Ani was the victim of two separate assaults in this case, two independent assaults, one by my client, appellant, and one by Phoenix.
What's the connection between the two assaults? Were they, what leads you to say that they were not in concert?
There was no community of purpose.
It seems like you get the first incident, and then someone tries to help, and your client chases him, and then you get the second incident. Why couldn't we infer that this was really kind of a plan together to do this, to hurt this?
Because there was no evidence, Your Honor, of there being a plan together. I mean, we have in this case, fortunately, a third man in the SUV who testified very well for the people. If there had been any verbal communication between the two.
So it would be enough if one says, I'll chase him, you hit him, that's clearly enough, right? I'll chase the other guy.
Well, if there was something like that.
You finish him off, whatever, that's evidence.
If there was something like that, or if there was, let's go get him, there was nothing like that.
What if he nods to the other guy?
There was
and then goes to chase, and this guy comes. That would be enough?
Again, yes. There was no indication.
So your view is nothing here?
There was nothing here.
So what happened? There were two isolated events?
Yes. My client was sitting in the back seat smoking. The window was open. One of the gentlemen spit through the window, got him annoyed. He ran out and hit Jose over the head, and then ran after the brother Rommel.
But doing so then leaves the decedent
correct.
On the ground, alone, defenseless.
Yes.
What did you think was going to happen?
There was no plan ahead of time.
Why couldn't the jury infer that perhaps there's an understanding that if you run and leave this man on the ground?
Oddly enough, Your Honor, if there wasn't for the third gentleman present, Nathaniel, perhaps they could have inferred. But we had a witness here who testified. He was a star witness for the people. Yeah. Didn't testify to any communication.
But does there have to be overt communication? I mean, what about foreseeability? What about the fact that here they are, they're driving together, this whole thing unwraps, and the victim ends up kicking the car after the driver has yelled these epithets. Isn't there something that defendant can be inferred that he knew that if he got out of the car and he did this, and that the driver was coming right after him and he was going to finish the guy off? Is that enough?
I don't think so, Your Honor.
Did he know there was a baseball bat?
He knew there was a baseball bat in the car. There's no reason for us to assume that he knew the baseball bat was going to be used as a weapon. I mean, it could have been simply.
What about if they said, let's go get those gay people? Let's go get him. He goes out. He does what he does. Then he runs after the other guy. The other guy. Then Phoenix comes out, hits him with the bat. That would be enough to show.
I believe so. If there was a let's go get him.
So there has to be some overt
statement. There has to be something. Either verbal communication, Your Honor.
What if it wasn't a bias situation? It doesn't say let's go get gay people, whatever. Let's get these kids. That's enough too, right?
Even then, that would establish that there was some plan, that there was a shared purpose between the two. Actually, I think here is the district attorney's brief also.
Why does the purpose have to be determined when he's in the car?
I'm sorry, Your Honor.
Why can't it be he steps out, they're in this melee, and at that point there's an understanding? Why does it have to be they figured out in the car, let's proceed as follows?
Because even when they got out of the car, Nathaniel said he got out of the car very quickly. He said nothing about any communication between them. He said nothing about any gestures between them. There was nothing like pointing to the guy.
Isn't it enough if they show that he intentionally aided? One guy, he gets hit with the bottle the way I see this is a bad. The defendant comes out, hits him with the bottle. He chases his brother. He comes back. The other co-defendant's gotten out of the bar with the bat, hits him with the bat. And my understanding is there's evidence from a taxi driver that the defendant then kicked him, and that he kicked him, and then the causation evidence is then supplied by the doctor. So I thought, you can correct me if I'm wrong, I thought that you don't have to show that he importuned or discussed anything. He intentionally aided the person, and intent can be shown here by his acts. So how does this not meet the legal sufficiency standard then?
But there was no plan established. There was no plan shown.
And you're saying that a plan is required?
Well, there has to be some community of purpose. There has to be something where they shared an intent.
But you say the aiding each other in this assault isn't enough.
He didn't aid him beforehand.
Does it make any difference that he didn't come back and say, oh, my God, what did you do? That they drove off together?
No, Your Honor. He may not be a good guy, but there's still no proof that there was that he aided and abetted in Phoenix's.
In other words, he didn't express any surprise.
He said, let's get out of here. He did say, let's get out of here.
Well, that would seem to be well advised under the circumstances, I guess.
It seems what happened here, and I'm going to take the DA at what he said in his brief, that after my client got out and hit Jose over the head with the bottle, that Phoenix was spurred or an example was set for him, and then independently and spontaneously, he got out, pulled out his bat, and went and beat Jose over the head a few times.
Also, on that note, assuming they're two separate incidents, not an acting in concert, why isn't there sufficient evidence that what your client did in hitting Jose over the head with the bottle enough to show that he could have caused his death? And why couldn't the jury infer that from the evidence that was presented?
Well, the ME said that the murder was caused by a heavier object than a bottle and that he was hit by it multiple times. That had to be the bat. So it wasn't his hitting him with the bottle that caused his death.
The ME didn't say that he died from just the bat, right? I mean,
well, actually, I believe he did, although he didn't use the word bat. He did say, this is on cross-examination, and it's pointed to in my brief specifically. I don't remember the page offhand.
What I got is at 486, 487, he said that a person could sustain deadly injuries from a bottle breaking over his head and that both a bat and a bottle would qualify as a blunt instrument. That's what I got.
Correct, but later on.
So I can see the ambiguity you're arguing, but it doesn't, it's not.
Later on in the cross, when he's asked specifically, he said the weapon that killed him had to be more than a bottle, something heavier than a bottle, and that he was hit with it multiple times. Clearly, he was talking about the bat.
Well, he said that caused the skull fractures, but he said that there were also brain injuries, including bleeding around the brain, that were not necessarily associated with the fractures, and that such injuries could cause death as well.
Could cause death, but I believe the defense attorney specifically asked him on cross, and I think he specifically said the cause of death here was not from one hit with a bottle, but multiple hits with something heavier. Again, he was obviously talking.
The jury believed what he said in what my colleagues just read to you, as opposed to what he said later on cross-examination, and decided that your client caused this man's death, even if he were acting in concert with Phoenix.
It just seems as though the ME ended making it clear that the weapon that caused the man's death was the baseball bat.
Well, but what he didn't say may also, be a factor, and that is I didn't see where he ever said that the hit over the head with the bottle was not a contributing factor to the death. Maybe it wasn't the only factor, but he didn't say it wasn't a contributing factor.
No. I read the cross-examination with the ME stating that the weapon that caused his death was clearly the bat.
And the bottle wasn't a contributing factor? The ME said that? He discounted the bottle as a contributing factor?
Apparently, from what he said on cross, if it was just the bottle, he wouldn't have died.
Well,
But he said the death was caused by multiple hits with something heavier than the bottle.
And that's not enough for the jury?
I don't believe it is, no, Your Honor. I want to quickly move to the other point.
Have a minute, yeah.
Yes. This Court has said that a defendant has an absolute unequivocal right to be present when anything is told to the jury, instructions, supplemental instructions. And in this case, what was told to the jury, I don't believe can be called ministerial.
Well, but if we have a de minimis rule that applies to this, and I don't know if we do or not, but if we do, wouldn't this at least be de minimis given the circumstances here?
I don't think you do have a de minimis rule. The majority in Rivera said there isn't. Morales and Bragle together do not establish a de minimis rule. Bragle actually is an interesting case, 1882, before my time, but it said that the defendant had left the courtroom to make a phone call, but this court, the 1882 version of this court, ended up saying that he was in the courtroom. He was an appendage of the courtroom. So that case does not stand for de minimis.
Okay, Counsel. You'll have your rebuttal.
Thank you.
Good afternoon. My name is Seth Lieberman.
So what's the evidence, Counsel, that shows some kind of a act in concert in any way, sort of a shared purpose? What do you have here? It doesn't, on its surface, there's not too much to grab onto.
Your Honor, there's a lot.
Yeah, what is the lot?
I'll tell you. First, you have Rommel, the victim's brother, saying that both came out of the car, the SUV, simultaneously. It happened almost immediately after one of the brothers had kicked the car. It happens all the time that people are acting in concert without actually having an overt communication.
So there's nothing overt that has to happen that tells you that they're...
Well, for example, if you're at somebody's house for dinner and the dinner's ended and everybody starts getting up and starts clearing the table to help out the host, they're all acting in concert, but nobody said anything. Similarly here...
That's a far distance from someone being beaten to death by a bat when the other person isn't even near them.
Okay. So why are they getting out of the car? If they're getting out of the car...
The defendant could be planning to attack and then he ran after the other person, as opposed to this murder with the bat?
This happened within a matter of seconds on the spur of the moment. But if they're coming out simultaneously, they are aware of each other's conduct.
So that's the key piece of evidence in your mind, is that they came out simultaneously?
Well, that is absolutely key, and the fact that it was instigated by the kicking of the car, that they both reacted to that. The defendant knew that the co-defendant had a bat in the SUV, so why is he keeping this bat in the SUV? Obviously for use as a weapon in certain circumstances.
Wouldn't all of the information you just indicated apply as well to the was it the brother that testified for you?
Excuse me?
Nathaniel.
Yeah, is it Nathaniel? Yeah. Was your witness who testified as to what was going on?
There were several witnesses. We had multiple witnesses who were eyewitnesses.
Passenger. I think
Yeah.
Judge Pickett is
Well,
talking about the other passenger in the car.
Well, the passenger in the car...
Let's name him. What's his name?
Nathaniel. But he's one witness. He's one witness.
Right, but you said these three things happened. Nathaniel got out of the car. When the other two got out of the car, are we in concert of action?
No, Your Honor. This is the evidence viewed in the light most favorable to the people. So we look at the evidence that is most favorable to the people.
I understand that. And what I'm suggesting to you is you say these are the things that are most helpful to us. And I'm saying all those things that are most helpful to you to show this concert of action should have led to the indictment of the other passenger because he did exactly the same.
No, Your Honor. Nathaniel didn't do anything to hurt the victim.
Well, that's later on. You're trying to say they're in concert of action because they got out of the car. Well, so did the third passenger.
No, but
you're saying because they reacted to being kicked.
But let's not forget what preceded this. The driver of the car, unprovoked, before any of this happened, starts yelling hostilely to the two brothers, slurs.
That's my point, but that's okay. Go ahead.
Then explain it to me.
But Phoenix and the defendant weren't yelling hostilely, were they?
But the defendant, Phoenix is yelling hostilely. Phoenix is the co-defendant. Nathaniel is uninvolved. But defendant is involved in the sense that he knows.
What's the total involvement of defendant and Phoenix? What does defendant do?
Okay. The defendant gets out of the car, knocks the victim on the head, the bottle breaks, the victim falls to the ground.
And then goes and chases the other.
Right. But almost at the same time, according to Rommel,
what does Phoenix do?
Phoenix gets out of the car and grabs the bat from the back and starts whacking the victim on the ground. And
yeah, but do you think that the defendant said, okay, I'll hit him with the bottle, you get him with the bat? It doesn't, there's nothing that connects.
Is it your point, though, that he comes back with, after chasing the other brother and kicks him a few times, too, and there's some kicks also, so assault, isn't that what
I don't believe he comes back and kicks him after that.
Oh,
Yeah.
okay. All right.
But you know,
he gets in the car and drives away with him,
Right.
with Phoenix.
Right. But, okay, even if you don't accept the acting in concert theory, but I think there was obviously sufficient evidence for that, you have the defendant acting as a principal, and that theory has to be viewed in the context of the charge that's given to the jury, because there was no objection to the charge. And under those circumstances, you just look at the charge to determine whether the elements were established.
I could see I could see how you get close to joint assault, you know, but this business with defendant and manslaughter just doesn't seem to. You just don't have. It's really hard to get your arms around something that brings it together.
Okay, first of all, in the context of the charge, the people did not have to establish reasonable foreseeability. All they had to establish was that defendant was a contributory cause. In other words, he either set in motion the chain of events or forged a link in the chain of events. And by hitting the victim on the head, he rendered the victim totally defenseless. He then chases after the one person who is likely to come to the victim's assistance, the victim's brother.
What does the set in motion really mean? If I tap somebody or give them a light punch or whatever, and they go to the ground, and then you go away, and someone comes over afterwards and says, "Oh, the guy's on the ground defenseless. I'm going to beat him to death with a baseball bat." Defendant is not responsible for what the next person does.
Your Honor, we're talking.
What's the difference between this situation and that?
We're talking about causation, whether the defendant caused the death. And
I understand he caused him to go on the ground.
And immobilized him.
But the bottle didn't kill him, right?
No. Wait a second. He's knocked on the head with the bottle.
Yeah.
He's unconscious. He can't move. He can't defend himself.
Okay.
He can't escape. Then.
But say they weren't in the same car, these two guys, and that happens, and he's unconscious, and another person comes and beats the guy to death with a bat. Is the defendant responsible for what the second guy does?
First of all, under the charge, yes, because all they were charged with was causation. But let's go to the reasonable foreseeability aspect of it. With respect to reasonable foreseeability, the defendant is aware that Phoenix is really angry, just unprovoked initially.
So that's different than if someone who had no connection with him.
Absolutely. Absolutely. It adds so much more information to the
You're saying he's thinking, oh, he knows what happened. He knows the kicking the car, the spitting, or whatever the hell it was. So therefore,
can I just say something about the spitting? That's just coming from defendant's statement. So that should be totally discounted because we have to look at.
But your point is, I'm trying to get what the connection. Your point is that defendant knows a lot about Phoenix, knows a lot what led up to his hitting this guy with the bottle.
Exactly.
That's your basic. That's the cement that ties it, even if there's nothing over.
Absolutely. Absolutely. And he also knows about the bat.
Judge Fahey.
Yes.
Thank you. My understanding of your case is a little different than yours. The way I see the case is that there was, as far as the defendant goes, and the aiding question, he hits him with the bottle, he chases after the brother, and then he comes back. And after he's been, the victim has been hit with a baseball bat by the co-defendant, this defendant starts kicking him. And the way I read the record, he said he just started kicking him there. This is at page 102. He stayed there. Who? The one who had the bottle? Yes, and he never left. He was kicking him. So my reading of the record is that the taxi cab driver, Almonte, testifies that your client came, or not your client, I'm sorry, that the defendant came back and was kicking him. And so let me finish. That being the case, it supports your fundamental proposition. But if that's a misreading of it, if you say the proof is different than the way I read it.
Your Honor, if I'm presently not aware of that particular detail, but if that's correct.
It's 101, 102 in the record.
If that's correct, then that's great. Absolutely.
Well, I don't know if it's great, but it is what it is, right?
But right. It shows the acting in concert, the continuation. But the reasonable foreseeability is if you render somebody incapable of fleeing or defending himself, you chase after the person who could defend them, you're aware that some other person is really angry at the person, has a bat available, and is also relying on Romel's testimony that they come out simultaneously, is also aware that Phoenix has come out of the car, and for what purpose? To attack him, obviously, because he's really annoyed or angry that the guy has kicked his car, he's dissed his car. That's what he talks about afterwards. That's reasonable foreseeability.
Does it matter if he may think that he's going to attack him, but he has no idea that Phoenix is going to take a bat and beat him over the head several times and pummel him to death?
No,
does it matter if he might think we're just going to attack them?
Well, certainly
injure them.
That would be enough. But the fact that he knew about the bat, I think that adds so much more. But even if he wasn't aware of the bat, it would have been enough because he was sufficiently angry to know about the attack. And I just want to quickly say that in the event that you find that there wasn't legally sufficient evidence for manslaughter in the first degree, according to this Court's decision in Suarez v. Byrne, 10 New York 3rd 523, the proper remedy would be to remit to the trial court for a new trial on the counts that the jury did not consider.
Right.
So that includes the assault in the first degree. And so with respect to the instructions.
Quickly, Counselor, go ahead.
Not a violation of 31030 because it wasn't a response to.
But de minimis? Is that?
Absolutely de minimis, totally inconsequential about something.
Is that our rule?
Well, there is a de minimis rule. There is a rule regarding de minimis violation. If any case is a de minimis violation, this is it.
But you're saying it wasn't in response to a juror's question.
No, absolutely not. Absolutely not. This was totally coming from the court and the attorneys.
But if we say that jury instructions, whether it's the initial instruction or it's an instruction that comes following a question from the jury, I mean, why wouldn't all jury instructions be the same?
No, because a response to a request from a jury, that indicates, and this Court has said, that that could be determinative of the verdict because that shows what the jury is concerned about.
This was a correction. The initial jury instructions doesn't come from isn't based on a response.
That's correct.
That's the court instructing the jury. So in this case, what we essentially have is an addendum or an amendment to the jury instruction.
Right.
Because the court
made
a mistake.
But about a detail that's inconsequential.
Well, that's a different question.
And that's the de minimis violation.
Okay, Counsel.
Okay.
Thanks.
Thank you.
Rebuttal, Counsel. Counsel, what about this kicking business?
Actually, I believe the kicking, one of the other witnesses, I believe saw kicking before my client ran after Rummel. I don't believe there was, I don't recall there being kicking after he came back. At least that's the way.
I read it, you know, it kind of speaks for itself. It's El Monte. It's a 101, 102. You can look at it. Okay.
Thank you.
If you look at this thing, when I first looked at it, there's sort of like big concert of action and little concert of action. And, you know, when the first insult to the car happened, everybody in that car was going to get these two guys because they had dissed the car. And so, acting in concert, they did what they did. One guy went out with a bat and beat somebody up. One guy went out with a bottle and beat somebody. All of that was in concert of action. That's, to me, big concert of action. What seems to have devolved here is you want to say, well, within that, we can tease out these actions and say this one was not in concert with that one, and therefore it's insufficient. And that seems to me to be a flaw in the argument in terms of what concert of action actually means. Am I wrong?
I understand, Your Honor. But again, I believe even for there to be acting in concert in the first instance, there has to be some communication, verbal or physical, or there has to be some.
Have we ever said that, by the way, that there has to be some kind of verbal communication?
No, but there's been a number of cases where you've said there were gestures between the people and verbal. I mean, this was like instantaneous. My client got out of the car with the bottle. There was no. He had to intentionally.
What about the argument that your adversary is saying that, yeah, but he had a lot of knowledge when he jumped out about what Phoenix was doing or thinking or whatever? Does that make a difference?
I think it's pure speculation on top of speculation. I mean, again, I object to the fact that
there's got to be something.
Well, we have to assume that the bat was in the car as a weapon. I don't think that's reasonable, number one. Phoenix is the one that yelled slurs at the two men. My client, not only does the evidence show he did not, but the jury did not
But
find.
he knows, but your client knows that Phoenix is yelling slurs.
So in the moment that he runs out
Does
of
that
the
mean
car
anything?
to go after the guy with the bottle because he spit at him, he's got to be thinking that, well, Phoenix, I know, is really angry at him, and it was
So
his
you're
car.
saying it's just speculative?
It's just
Any
speculation.
way
It's
you
complete
cut.
speculation. Yes,
Well,
sir.
but what does he think is going to happen? Because he hits his decedent's down. Supposed to see him later. Anyway, he runs after the brother.
Right.
He's obviously, if he's running after the brother and he's running from where they're parked, he must be assuming they're going to wait for him. What does he think is going to happen in the interim?
First of all, he probably wasn't thinking, Your Honor. He certainly couldn't have foreseen that
Well, he's got to be
Phoenix
thinking,
was going to grab the
he's got to be
bat.
thinking something. I understand your point, but he's got to be thinking something. He's not going to go out in the middle of the night, 2 in the morning, whatever it was, complete dark, running off in the street without thinking he's got a way to get home.
You're
Must
correct.
anticipate the car will be there and they will be there. What is he going to? What is he
You're
think is going
absolutely
to happen
right.
in the
But I think it's really complete speculation that for him to have foreseen that Phoenix was going to take this bat, get out of the car, and beat the guy over the head multiple times.
Okay, counsel,
Thank
thank you
you.
both. Appreciate it.